feature. That way we can keep the audio pretty tight, and we do have a question and answer portion on the back end of this. So if you have questions, I would love to answer them if we can, without obviously going into anything that would be attorney-client privileged. But yeah, look forward to sharing with you. We'll go ahead and jump in. I'm going to move the, there we go. Let me just close that portion down. Very good. Okay. Well, it was a stressful last couple minutes. We were setting up our audio and stuff, and I'm working from my home office now because just recently I gave up my office at my office to another person because we're so tight on space. There's been a lot of growth happening, and anyways, as you can see, there's always some fun changes with that. But this is just a standard disclaimer. Again, we're lawyers, so we always have these disclaimers. But in truth, this information, there's constantly updating information happening, and it's going to be important to keep on top of everything that's happening. You'll see throughout this presentation that in the last not even a month now that President Biden's been in office, there's been quite a few changes that have taken place, and they span over a lot of different areas. But what today we'll be focusing on is labor and employment law specifically. So with the executive orders, proclamations, and memorandums, President Biden has been very active. The previous record for executive orders that happened was 30, set by FDR in the first month that he was in office. President Biden has already surpassed that, and we still got a few days left for him to take additional action. So he currently is at 32. That doesn't include some of the memorandums and other things that he's actually, the requests, he calls them, that he's put out there for these different government agencies to, he requests that they comply with those things. As many of you know, obviously we have our different branches of government. The legislature is who writes the laws. The executive branch, the president, is the one who enforces laws. But then there's this administrative arm, the bureaucracy they call it, that is the interpretation and enforcement and rule and regulation creation arm of the government. And so the president has a lot of oversight and ability to influence. This is not just President Biden, it's every president has a lot of ability to influence those bureaucratic arms. And so that's what most of these executive orders hit to. A lot of them actually target executive orders that President Trump put into effect, and he's retracting those. So things like the exit from the WHO, there's been climate control, stopping the border wall construction, COVID vaccines, the enforcement of immigration policy, and then even two that have been about strengthening the Affordable Care Act and almost reintroducing funding to some of those provisions of the Affordable Care Act. But for what we're talking about today, my primary focus will be on what impacts labor and employment directly. So we obviously won't be going over all 32 executive orders or even all the other memorandums or requests. So let's jump into those. There's a few that affect employment law directly, and that is the initiative or the executive order relating to the enforcement of and prohibition of discrimination based on sexual orientation and gender identity. Everybody, it's a little confusing when you're looking at these, enforcements of this specifically, sexual orientation and gender identity. The reason it's actually not black and white in the what's called Title VII or the Civil Rights Act. Title VII of the Civil Rights Act uses the term that you shall not discriminate based on sex. Now, this is the arm of sex that has expanded into sexual orientation and gender identity. So in the law itself, it doesn't define the word sex as including these, but you've seen recent court cases, the Equal Employment Opportunity Commission, and then even executive orders that have now tried to include or have said, hey, that word sex does in fact include these categories. And this is not my view as to whether they should or should not. It is simply that's what the law currently is. And so for employers, one of the things you have to expect, and we'll go over this later with the EEOC changes, one of the things you have to expect is there will be a lot stricter enforcement of these categories. Sexual orientation, gender identity will be enforced categories. So if you have discrimination in the workplace based upon those, likely going to have legal issues coming forward. And so the second is, it's kind of a secondary but similar one to that executive order, advancing racial equality and support for underserved communities. it actually is setting up in the agencies, it's asking all the agencies to look at and find what types of discrimination are we seeing for underserved or underprivileged in the way that the government is defining it. So we have LGBTQ, we have race, we have gender, we have disabled, there's veterans. They're going to be going through all those different categories and saying, hey, what are ways that these people are being underprivileged, and how, as an executive arm, the bureaucratic arm, how can we make regulations that make it so that we think they're not underprivileged? The next thing is, I think it may not be the most impactful to start with, but it actually is showing a lot of trends with what President Biden has promised in his campaign and what he's already started doing with different things that he's done, and we'll go over that again later. The collective bargaining power and worker protection. This only targets specifically federal employees, but President Biden has been very pro-union, very pro-collective bargaining. And so as an employer, these are things that we are going to be watching obviously very closely. In this specifically, during Trump's administration, he had pulled back on some of the ability for, well, I should say he pulled back on some protections, they call it, for these federal employees so that they couldn't be terminated without cause. What that means is in a normal employment situation in Arizona, when you're an at-will employee, the employee can quit or the employer can terminate them for any reason, including no reason at all. Well, in the federal government, there's certain divisions and departments that say, hey, you can't do that. You have to have a cause to terminate this person. What Biden has said is, well, we're going to reinstitute that you can only terminate for cause. The other thing that he's talked about and has put in this executive order is that he wants to encourage the collective bargaining of federal employees. So for increased pay and better benefits specifically. That goes into some of the requests that we're going to go into next. So the executive requests, one of them is having the Office of Personnel Management look into what the impact of a $15 minimum wage for federal employees would have. Back to that last executive order, there's no secret. We all know there's a big push, even right now in this last stimulus bill, to get the minimum wage, not just for federal employees, but for all employees to be set at $15 per hour. So this is Biden's first kind of foray into that push himself, which is, hey, let's look at the federal sector. Those are the employees that we control. Let's see what the impact would be if we raise it to $15 an hour for minimum wage. Second thing is the request for OSHA to issue guidance on COVID-19 safety measures. Many of you know OSHA is the Office of Safety and Health Administration, and what they do is they're going to be looking at, they are there to ensure the protection of worker safety. That includes, if you ever have done or work in construction, things like, hey, you have to wear harnesses if you're up on a roof. In this specific instance, though, they're asking OSHA to issue guidance on, hey, these are the measures that employers should take if they're going to keep their workplace safe from COVID. And if they don't, we all know there's always an if you don't. If you don't, then what happens? As with most government agencies, they haven't spelled this out yet, but with most government agencies and most rules, if you don't means we will penalize you. And what I found is with most OSHA investigations or any federal agency, I've done Department of Labor, OSHA, they don't always stop with just the issue at hand, right? So if they come in to look at, hey, did you comply completely with our guidance on keeping your workplace safe for COVID? Their review of your workplace will be expansive, and oftentimes the initial inquiry that sparked an agency investigation is the smallest infraction, and it actually, you open up a lot of different issues. So those are things to look at. I'll keep you updated on what guidance they issue. It's unclear. The president doesn't have the authority to issue a mandate for all people to wear masks everywhere. But obviously he's already done that with any federal land. Anywhere you go that's on federal land, you have to wear a mask. So I'm going to guess that's going to be part of their OSHA guidance and suggestions. Maybe even bigger than those executive orders related to labor and employment are the recent appointments that President Biden has made. And one of them is, and I'll go through three different departments. One is the National Labor Relations Board. The National Labor Relations Board covers or enforces the National Labor Relations Act. And what that is it's actually for collective bargaining. In Arizona, We don't really know much about it just because we don't have a lot of unions here. But what it does is there's one small part of that law that says if an employee engages in a concerted activity, which is if they talk to one or more of their coworkers about any conditions of the workplace, they are protected under the National Labor Relations Act. In the past, the Labor Relations Board really didn't have a lot of enforcement teeth. The law, the way it was written, didn't have a lot of teeth to do a lot of things. There's talks already of those things changing. And so one of the things is President Biden actually did fire the general counsel for the National Labor Relations Board. That's the first time that's ever been done, in fact. And some of you might be surprised. I was surprised, thinking for sure Trump's done that before, right? No, the first time that a National Labor Relations Board general counsel, who's the head of the board, of the division, I should say, has been fired. He's got Lauren McFerrin. So there's a 5-member board ultimately, almost if you think about it like their own mini Supreme Court of this little department. They have a 5-member board, and it's typically split 3-2, Republican, Democrat, or 3 Democrat, 2 Republican board members. Right now it's 2-2. President Trump had not filled one of the seats. That seat will be filled soon, and that's going to put it to a 3-2 board, meaning Democrats 3, Republicans 2. There's also talks of maybe even wiping out the other 2 Republicans on the board and just putting a 5-0 Democrat to Republican split. With that, there are several things to look out for with this new board. One of them is making it easier for the National Labor Relations Board and others to find a joint employer relationship. So let's say you share employees, or you have a parent subsidiary company, or you have a work share relationship with a company. Those are often, that they look to find a joint employer relationship there so that the employee can seek remedies against both employers. During Trump's era, that was actually put into a very tight box. They could only go after one employer or the other. The second thing is restrictions on employer being able to keep workplace investigations confidential. Essentially, we have, and I just did one recently, you can do these workplace investigations. They are covered under, there's different attorney-client privileges, there's different work product privileges, and what the new administration would like to do is say, hey, if there's an issue at work that you have to address, we basically want to open up any and all interviews, any and all things that you've discovered, and let that be public knowledge. Obviously, there's concerns for many reasons on that. For employers, employees being able to use their employer's electronic communication systems for collective bargaining purposes. That's a big one. So think about your email system. Think about anything. Obviously, in a smaller workplace, not as big of a deal. But to a lot of mid to larger employers, granting employees the platform, your platform that you've paid for to use to instigate potential union type of activities is concerning. And then finally, making it easier to find that an individual is an employee and not an independent contractor. That's a general theme that you're going to see in multiple departments. The independent contractor misclassification has been a big push of the Department of Labor for a little while. Now it's being spread, and even more emphasis is being put on that. So one of them is a tax reason. The second reason, though, is so that you can actually say, hey, you as the employer weren't giving the benefits, or you discriminated against them, and now you're covered under Title VII of the EEOC. So there's different reasons for that. So let's go to the next department. The Department of Labor. It controls wage and hour, employee classification, we just went over that a little bit, safety and health of employees, and the employee benefits. That's what they call ERISA laws. Department of Labor enforces that. This is a really interesting thing because President Biden has already appointed the Secretary of Labor, and that person is a former union president. That tells us a lot about the indications of where President Biden's agenda is, as well as what they're likely to do moving forward. The expectations on things that they're going to crack down on, again, misclassification of employees as independent contractors. In this specific instance, this goes directly to those employees, these people getting minimum wage which again, they want to bump up to $15 an hour. So if you are classifying the people right and they're supposed to be employees, bump that minimum wage up to $15 an hour. Secondly, overtime. A lot of people have either misclassified or salary exempt misclassified employees, and so they're not getting overtime. The other things are increased individual liability for corporate officers for violating labor laws. This is big. Under most labor laws, you, the owner or the manager, you're not personally liable for, let's say you fail to pay somebody appropriately for overtime or minimum wage. They're trying to increase that individual liability, basically increase the skin in the game of these individual owners, small business owners, mid-sized business owners, and if they are liable, to be able to go after their personal assets. Ensuring federal contracts don't go to individuals that are anti-union or who have been alleged to violate labor laws. This one, not many people, I've done some work with people that have federal contracts, but in the sense, if you do, this is something to be very keen on. If you have any violations of labor laws, they're looking to say, hey, let's yank their ability to receive these federal contracts. Enact federal ban on right to work states. That's huge. Right now in Arizona, it is a right to work state. Many states are. What that means is if you are an employee, you are not forced to join in and pay union dues if there's a union in your specific workplace or within a group or industry. Right to work, banning that right to work laws basically forces buy-in. You know, you can basically say, hey, you have to contribute dues. Even if you don't want to be a full-fledged participant in this union, you have to contribute dues so that we can collectively bargain and increase, you know, benefits or pay. Finally, the last thing is enact a federal ban on non-compete and anti-poaching. Non-compete, I think probably I'm honestly less worried about. I think there's really the bigger thing is anti-poaching and non-solicit. So anti-poaching is if you're going to take other employees away from workplaces. Non-solicit is typically referring to, hey, you can't turn my vendors against me. You can't take my clients away from me. Those types of things are, I think, a lot more impactful. So we'll see what they do with that. California obviously already has a no, you can't have a non-compete. Some states are already enacting those laws as it is. Okay, next up is the EEOC, and this one's pretty quick. He's already appointed a new lead commissioner, Commissioner Burrows. The interesting thing about this EEOC is the board is currently 3-2, a Republican majority, a Democrat minority. The position won't be open to fill until July 2022. So this will be, any enforcement measures here will likely be a little bit slower on the EEOC side, just because you still have a 3-2 majority of Republican. And again, I'm not saying whether you are Republican or Democrat, it's bad either way. I'm just saying this is likely going to be a slower process for this EEOC to enact change from a Trump administration to a Biden administration. Some things to look out for specifically are more aggressive enforcement of gender identity and sexual orientation matters. And then second is for those employers who have more than 100 employees, that you have to file an EEO-1 report each year. Those reports have entailed different things. One of the things that they would like to bring back, it was part of the Obama administration, is reporting pay to specific individuals to determine if there's a gender inequality pay gap there. So not anything huge currently. You'll see again probably the continued emphasis on gender identity and sexual orientation enforcement, so there's no discrimination on those matters. Upcoming or actually pending legislation is something that we're really going to be tracking pretty tightly here in the next year. Obviously, there's a House majority Democrats, and then there's a 50-50 split in the Senate. We have different, obviously, senators that can vote either way on the aisle, and so a lot of this legislation has a chance to pass during especially the first 2 years of the Biden administration. One is the Public Service Freedom Act, and the other that kind of dovetails with that is the Public Safety Employer-Employee Cooperation Act. Basically, it's to ensure that state and federal employees have the right to unionize. The second goes to the private sector. This one passed the House recently. It's said not to be likely to pass the Senate, but it's more of a warning call. Protecting the Right to Organize Act. It's called the PRO Act. This is a strong very pro-union legislation, which, and I'm just reading a few things here. This is just the highlights, honestly. Imposes personal liability on managers, owners for labor law violations, ensures workers the ability to strike without the employer being able to replace them long term. There's a lot of other provisions with that PRO Act that honestly would drastically alter the current state in which many of the people I represent operates. And so things to look at, and I'll keep you updated there. So what should you do now? The writing's on the wall. The executive arm is going to start enforcing things in certain ways. There's going to be a legislative push to be a lot more aggressive in certain ways. The writing's on the wall to tighten up things that are happening in the workplace. Those things that you should be looking at immediately are your independent contractor classification. Are you properly classifying these people as employees, or should they be independent contractors? A good rule of thumb is, does the person rely on you solely for their sole source of income? And then secondly, a lot of people get caught on this control factor. Do you control the terms and conditions of their work? That's a big one. But do they have a separate legal entity that they operate independent of you? Or are they really providing a function that other people in your work provide, or it's a primary function of what you actually do? If that's the case, then there could be a misclassification. The salary exemption status is another one. That's a big one. The salary exemption threshold jumped. A lot of people don't realize this yet. It used to be at 24,000. Now it's at 36,580. And so if you don't have a minimum threshold of salary for a person at 36,580, then they're going to be entitled to overtime. Review employment handbook provisions. Again, one of the things I've looked at recently, this kind of went along with the last webinar that we did about the passing of legalized marijuana in Arizona. You have to look at your drug enforcement policies, see if you actually are following or complying with those laws. Secondly is outfitting your EEO policy, which is, hey, you got to make sure you're including gender identity and sexual orientation in those do not discriminate against categories. The next thing is you have to actually review what is happening in the workplace, right? Too often we have really great employers, but then there's things on the back end that happen where you've got a one-off manager, or you've got people that are lower level that are doing things, saying things that are not really what you would have them do, but it does create liability for you in those instances. So that's important. And then obviously providing the training to your managers. What's correct? What can you say? What can't you say? When can you discipline somebody? When can you not? It's important to have that nailed down. Just so you know, we do provide employment audits. So we go through all the labor and employment law practices for companies to audit them and say, hey, this is what's up to par, this is what's not. This outlines for you here all the things that we would look at. There are more, but this is the highlights. The thing that I will tell each of you right now, if you haven't done it yet, many people, the new year comes and it just kind of hits you in a flurry. The thing that many people don't do regularly enough is get your labor law posters up to date yearly and post them in a spot in your office where all employees have the ability to view or access them. Honestly, that's the #1 violation I see when any federal or state agency comes in and does an audit. They first look for those posters. And if you don't have them, you're in a bad spot. They kind of look at you like, oh, well, you're trying to hide something. So if that's the first thing you can do, and if you need help getting those, we can. But that's the first thing that you need to focus on. Otherwise, we'd be happy to provide a full audit of your employment law practices. Make sure you're up to snuff on those. That is it for my talking points. So I'm going to go ahead and expand the view here. Really appreciate everybody joining on. I know there's a lot of information. Some of it is, the writing on the wall, and some of it's actually already happened. So if you have questions, feel free to send a chat, or if you'd like, feel free to unmute yourself. I'd be happy to answer questions again. If it's relating directly to your company, probably don't share it too much because we can talk where it's a more private conversation. And I'm still working out the controls on my end to figure out how to do all this. So if you do chat, then it may take me a minute to see it. One thing I did fail to mention too is people asked after they emailed me after, hey, can you send a link to the information you had? Yes, we do post the link. We can send the link out for this entire video. So if you need that, let us know. We'd be happy to send it to you. Oops, scrolling back. There you go. Okay. Well, thank you so much. I didn't hear any comments or questions, and I didn't see any chat. So we're going to go ahead and end this today. If you have private questions, let me see. I did get one chat. I'm trying to work it. Yep, there we go. Can you send the link? Excellent. The question was, can you send the link? And yes, the answer is yes. But no, I appreciate your time today. If you have questions, follow up, ask us. We'd be happy to help. Otherwise, thank you, and we'll talk to you next month. Thank you.